Good morning, everyone. It is my absolute pleasure to welcome you to today's webinar on medical information and human rights at work. It is my honor to be joined by our panelists, medical professionals, human resource professionals, and members from the public from all across the province. My name is Zara Ismail, and I am the Manager of Public Information and Education at the Alberta Human Rights Commission, and I am pleased to be moderating today's discussion. I would like to begin by acknowledging the land on which we are joining today. The Alberta Human Rights Commission acknowledges that what we call Alberta are the traditional and ancestral territories and gathering place for diverse Indigenous peoples. This includes 45 First Nations and 140 reserves who are subject to Treaties 4, 6, 7, 8, and 10, Métis settlements and lands, the 5 territories of the Métis Nation of Alberta, and the Inuit who have lived on and cared for these lands for generations. More than ever, Indigenous human rights are front and center. We are all being called on to take meaningful action to ensure that our organizations are barrier-free and that our programs and services meet the needs of and are accessible to Indigenous Albertans. As part of our own Indigenous human rights strategy, the Commission has committed to reviewing our programs and services in consultation with our Indigenous Advisory Circle and the community to ensure that they are culturally relevant and center Indigenous perspectives, issues, and ways of knowing. We are grateful for the traditional knowledge keepers and elders who are still with us today and for those who have gone before us. We make this acknowledgement as an act of reconciliation and gratitude to those whose territory we reside on. No matter where you are joining from today, I encourage each of you to spend a moment reflecting on the land where you work, play, and live, and how you can forward truth and reconciliation in your community, work, and life. A quick disclaimer before we jump into our session today. Please note that while the content of today's webinar will contain legal information, it is not intended to be legal advice. Additionally, to ensure that everyone can fully engage with today's content, I would like to highlight some key housekeeping and accessibility information. We are recording today's webinar and will send out a link to the video once it's available for you to rewatch and share. We are also pleased to offer American Sign Language interpretation provided by Flick Interpreting and closed captioning services courtesy of Accurate Real Time. These services are available via the toolbar at the bottom of your Zoom window. We will also be sharing a link in the chat for you to access closed captioning if you wish. Thank you to those who submitted questions in advance of today's session. While there will be no question and answer period for this webinar, we will attempt to answer the questions submitted to us at registration through the content of our discussion today. Lastly, near the end of our session, you will be prompted to fill out a short survey. Please fill this out as your feedback is incredibly valuable to us in making these sessions as impactful as possible, and it also supports the planning of future opportunities. So thank you so much for doing that. Before jumping into today's discussion, I wanted to provide a bit of background information on the Commission. The Alberta Human Rights Commission is an independent commission of the Government of Alberta, created by the Alberta Human Rights Act. Our mandate is to foster equality and reduce discrimination, and we do so by providing public information and education programs like today's webinar, and by helping people resolve human rights complaints. For more information on the Commission, please check out our website and subscribe to our social media channels. Today's webinar is to support the republication of the Commission's Obtaining and Responding to Medical Information in the Workplace Guide. This 2025 version of the guide includes current case law, as well as relevant Alberta cases, and an updated Commission policies and guidelines. This guide informs employers, employees, trade unions, and doctors on their role in gathering reasonable medical information in disability, injury, or illness situations. The guide also includes a sample medical absence form and a sample medical ability to work form for employers and employees. We also have these forms available as standalone forms on our website. Now, while today's discussion is about our recently published guide, the Commission has many resources available on a variety of human rights topics. And these resources include short information sheets, in-depth guides, videos, toolkits, promotional items, and more. And I encourage you to visit our website to explore our offerings or get in touch with us if you would like to order paper copies for your workplace. We are also pleased to offer online workshops on human rights in the workplace several times a year. These workshops are a valuable opportunity to learn about human rights in an interactive environment. You can register for these workshops via our website, with our next session occurring in February 2026. Lastly, if you require human rights information, we invite you to access our confidential inquiry line, where you can speak to a human rights officer in real time. Please refer to the Zoom chat for information on all of the resources I just spoke to. Now let's go ahead and delve into today's webinar. It is my pleasure to introduce our three panelists who will be sharing their insights, expertise, and experience with us. Our first panelist is Sanjana Ahmed. Sanjana began her legal career in the Edmonton office of a regional law firm. She practiced in the area of general litigation with a focus on Indigenous, labor, and employment matters. Sanjana is now legal counsel to the director at the Alberta Human Rights Commission. In this role, she addresses allegations under the Alberta Human Rights Act in the areas of employment, tenancy, and goods and services, as well as novel issues that are raised to ensure fair and equitable treatment of all Albertans. Good morning, Sanjana. Thank you so much for joining us today.
Good morning, everyone. Pleasure to be here.
Our next panelist is Leanne Monsma. Leanne is a lawyer practicing in the areas of human rights, privacy, labor, and employment at Field Law in Edmonton. She has represented clients at all levels of court in Alberta and regularly appears before administrative tribunals such as the Alberta Human Rights Commission, the Alberta Labor Relations Board, and the Office of the Information and Privacy Commissioner. In her human rights practice, Leanne regularly advises employers and service providers on a range of matters. In her privacy practice, Leanne advises her public and private sector clients on meeting their legislative obligations and responding to access requests or privacy complaints. Leanne also co-teaches Canadian human rights law at the University of Alberta Faculty of Law, and she holds a Master's of Laws degree focused on the intersection of human rights and privacy law. Welcome, Leanne. It's a pleasure to have you joining us today.
Thanks, Sarah.
And finally, our third panelist is Dr. Dawn Hartfield. Dr. Hartfield is the Deputy Registrar and Hearings Director at the College of Physicians and Surgeons of Alberta, CPSA. She was a faculty member at the University of Alberta in the Department of Pediatrics from 2003 to 2020, during which time she completed her Master of Public Health in Clinical Epidemiology and earned the rank of professor. Dr. Hartfield has attained expertise in quality improvement and patient safety, where she has held successive leadership roles in the healthcare system for nearly 2 decades prior to coming to the CPSA. At the CPSA, Dr. Hartfield has provided leadership across several key areas, including the continuing competence and accreditation programs, and previously served as complaints director for nearly 3 years. In her current role as Deputy Registrar and Hearings Director, she oversees the organization's regulatory departments and the Standards of Practice program. Thank you for joining us, Dr. Hartfield. We're thrilled to have you here.
It's a pleasure to be here with everyone today. Thank you.
Now that you know a bit more about our panelists, let's go ahead and kick off today's discussion. My first question for all of you is, what are the key laws related to obtaining and responding medical information in the workplace? And who is involved in that process? Leanne, I'm going to turn to you first with this question.
Sure. I'll tackle the second part of the question first. The people involved in the process will always include the employer and the employee. A healthcare provider will typically be involved as well. And then in some cases, other parties may be involved too. So, for example, where the employee belongs to a union, the union may get involved in the discussion. And similarly, where the employer uses a third party for the adjudication and administration of benefits, that third party may be involved as well. And then, as for the first part of your question relating to the key laws here, the most important statute in this realm is the Alberta Human Rights Act. As most here are likely aware, it's this act that prohibits an employer from discriminating against an employee. Now, the act itself doesn't specifically speak to obtaining and responding to medical information. However, from the cases and decisions that have applied the act, we know a little bit more about obtaining and responding to medical information. So from these cases, we know that an employer must provide accommodations to employees who require them. There are a couple of limitations here. So first, an employee is only entitled to accommodations if they have a protected characteristic under the Act. And an employer is only required to provide accommodations to the point of undue hardship. But all of this helps us to understand the law when it comes to obtaining and responding to medical information. An employer is entitled to medical information to help it determine whether an employee is entitled to accommodation, so basically whether the employee has a physical or mental disability. And the employer is also entitled to medical information to help it understand what accommodations the employee requires, and also whether the employer is capable of providing those accommodations. And then the flip side of all of that is that if an employee is seeking accommodations from their employer, then the employee is required to provide that medical information to the employer. And again, all of that flows from the Alberta Human Rights Act and the common law. I should also quickly mention privacy laws here. So in the private sector, the Personal Information Protection Act governs. In the public sector, the most relevant piece of legislation is the Protection of Privacy Act. And those two pieces of legislation place restrictions on how an employer can collect, use, and disclose an employee's personal information. Now, medical information most definitely constitutes personal information under both acts. So an employer needs to ensure that it's collecting, using, and disclosing an employee's medical information in accordance with those pieces of legislation. But having said that, both acts recognize an employer's ability to collect, use, and disclose an employee's personal information when the employer has the employee's consent to do so. And in most cases, when we're dealing with the flow of medical information, in order to determine accommodations, the employee has provided their consent. So it's good to be aware of the privacy laws, but I think the more important or relevant laws are the ones set out in the Human Rights Act.
Thank you, Leanne. That's really helpful. Sanjana, what would you add to this from your perspective?
Thank you, Zara. So what I'd like to add is complaints to the Commission addressing workplace requests for medical information typically engage the protected grounds of mental and physical disability under the Alberta Human Rights Act. Of course, it can involve other grounds. For example, an employee seeking medical accommodation for pregnancy could engage the protected grounds of physical disability and gender. Now, a disability is defined as a condition that entails a certain measure of severity, permanence, and persistence. This means a health condition that is serious, ongoing, and has real impacts on daily life or work. The Court of Queen's Bench, as it then was, recognized the severity, permanence, and persistence definition in a 2015 decision called Syncrude Canada Limited versus Saunders. The legal principle of the duty to inquire is also important in the context of obtaining medical information. This duty arises when an employer knows or reasonably ought to know that an employee may have a disability that could require accommodation. Now, employers are not expected to diagnose or speculate, but there are clear indicators, when there are clear indicators that an employee might be struggling due to a medical condition, the employer must take reasonable steps to ask whether support or accommodation is needed. In practice, this often means initiating a conversation and, where appropriate, requesting medical information to understand the employee's functional limitations and determine what accommodation may be required. As Leanne noted, employers may request information that is reasonably necessary, and that's the key word here, reasonably, to confirm any of the following: that there is in fact an absence for medical reasons, to assess return to work readiness. Can the employee safely be placed back into the role they held prior to the leave of absence? Or do they need to be placed in a different role because they now have restrictions? To explore accommodation needs. For example, if an employee cannot be placed into the role they held prior to their leave, can the employer accommodate them by placing them in a different role? Other examples of accommodation needs include any functional restrictions that the employee may have upon returning to work, the expected duration of these restrictions, how long these restrictions will last for, and whether treatment for their medical condition affects job performance. Employees also have a duty to cooperate in the accommodation process, which includes providing reasonable medical information to support their needs to their employer. The duty to cooperate involves informing the employer of accommodation needs and providing reasonable medical information to allow the employer to assess those needs, and we will be addressing this duty in more detail later in our discussions.
Thanks, Sanjana. I'm interested to hear your perspective, Dr. Hartfield.
Thank you. It's interesting to hear the importance of the various legislation. And then I'm going to layer some more on top of that apply to healthcare providers. So all healthcare providers who are regulated in Alberta operate under the Health Professions Act. And the Health Professions Act also requires regulators to have things called standards of practice. So these are minimum standards that will govern how providers do different parts of their work. And we do have standards of practice that are relevant to what we're speaking of today. In addition to the privacy legislation described, healthcare providers also must adhere to the Health Information Act that also provides them with requirements of how they handle medical information. And it's critically important that the provider's role in this is that they understand what their role is in these situations so that they're providing the appropriate information that's legally, ethically, and in the patient's best interest. In this setting, it's important that physicians comply with privacy laws as previously described. When a third party requests medical information, so an employer or an insurer, physicians must obtain consent, so informed consent, before responding to the request. As you know, we've indicated previously, only information that's directly relevant to the request should be shared. And sometimes physicians will receive forms, and it's important that they complete these to the best of their ability and within their scope of practice. And sometimes the requests that's come to them might be outside of their scope. And it's important that they work with the patient and with the employer, if that's the case, to ensure that they're getting the best opinion. So occupational medicine specialists, for example, can be invaluable in complex situations between employees and employers. And again, the human rights and employment law also applies. So there's lots on providers' plates when they're looking at how they respond to such requests. And as been described, it's important that providers understand the definitions of disability, their responsibilities, the employer's responsibility to provide accommodations up to the point of undue hardship, and the framework for which how medical information supports accommodation decisions and the appropriate response to these requests.
Thank you, Dr. Hartfield. That's very helpful. My next question is maybe building on this, and is around the timing of medical information. So what I'd like to know is, what medical information can an employer ask for at different stages, and when is it appropriate to do so? So for example, when an employee calls in sick, can an employer ask why? And does the length of time somebody is away change the information an employer can ask for? Sanjana, I'd love to hear from you first on this one.
Sure. So the first point to emphasize is that there is no one-size-fits-all approach. Requests for medical information are always fact-specific on the employee's accommodation needs. The information an employer is entitled to will vary depending on the stage of the accommodation request. So at the start, the employer only needs confirmation that someone is away for medical reasons and for how long they expect to be away. If that leave continues, then it becomes reasonable for the employer to ask for more detailed functional information, not a diagnosis, to understand how to plan for return to work and what accommodations might be needed once the employee does return. And then finally, when somebody is ready to return to work, employers can ask for functional ability information to ensure that the person can safely do the job that they have been assigned to do. So yes, the length and stage of the absence matters, but requests must always stay focused, necessary, and proportionate, and should never be intrusive. So what sort of information can an employer ask for? Well, employers may request information to confirm that a workplace absence was due to a medical reason, to assess fitness to return to work after a medical leave, to understand restrictions and limitations for accommodation, and to decide reasonable accommodation and whether undue hardship would result if they were to consider those accommodation options. Employees are also entitled to take an active role in requests for their medical information by asking how their medical information will be used, who will have access to this information, and how will this confidential and personal information be protected.
Thank you, Sanjana. That's really helpful. Leanne, what would you add from your perspective?
Yeah, so picking up on a few things that Sanjana mentioned here, I think it's important for an employer to consider both what they can legally ask for, as well as what it makes sense for them from a practical perspective to ask for. So in other words, just because an employer might be within their rights to request certain medical information doesn't necessarily mean that it should. On the practical side of things, a couple of important considerations for an employer in deciding whether to request medical information or what medical information to request is the impact that the request will have on the relationship with this and other employees. And another thing worth considering is the administrative burden of dealing with having that medical information. If it makes practical sense for an employer to request medical information, then the amount or degree of medical information that the employer may legally request is going to be dependent on the circumstances, as Sanjana said. As a general rule, the longer the absence and the more significant the requested accommodations, the more medical information the employer will be entitled to. And another important factor here is how safety sensitive the workplace is and the employee's duties are. So page 6 of the Commission's guide outlines what medical information an employer may be entitled to request. And that list includes 5 different things. 1, details surrounding the nature of the illness, but note here that it's a very well accepted rule that an employer is not entitled to know the specific diagnosis. Number 2 is whether the illness is permanent or temporary. Number 3 is the restrictions or limitations that flow from the illness, particularly as they relate to the employee's duties and responsibilities. 4 is the basis for the medical conclusions. And 5 is the treatment, including any possible side effects, and in particular, how they might impact the employee's ability to perform their job. So when an employer considers that list and what information to ask for, it should keep in mind the practicalities of the situation, as well as how long the employee has been away and what accommodations the employee is requesting. And then the last thing that I'll say here is that an employer can request information incrementally. So it's not as though an employer only gets one opportunity to ask for medical information. They can request some information, and then upon reviewing that information, they may decide that they have follow-up questions, and that's okay. So employers don't have to feel like they only get one chance to ask for every piece of information that they might need at some point down the road. And privacy legislation imposes a requirement on employers to be reasonable in terms of what personal information they collect and use. And asking for medical information incrementally can be a good way to make sure that employers are fulfilling that legal obligation there.
Thank you, Leanne, and thank you for that great breakdown. Dr. Hartfield, from your perspective, what information can a doctor ask for when providing a medical note or medical information for work?
Yeah. I think when an employee sees a physician, they will need to ask relevant questions that are medically related so they can understand what the issue and determine fitness for their work. And the working with the employee to ensure that there's informed consent ahead of time. It's extremely helpful for the employee to come in with the questions that their employer does have, so that they're able to guide, so they're able to ask the right questions so that they can get the information that's needed to really understand the functional impact of the medical issue. So again, when seeing the patient and providing the information to the employer, things that would be included in the details they need to understand are confirming that the patient was seen, so the date, the functional impact of the medical issue in the context of what the duties are in the workplace. And that's the thing that's really important. The expected duration, if known, of how long the impact of the medical issue may be, and what the prognosis may be when relevant. And so, for example, if there's the ability to have a gradual increase in physical duties after a surgery, for example. And again, providing the right amount of information at different time intervals, depending on how a medical condition might be evolving, is key here. So they're providing the appropriate amount of information at the right time. And we don't always know or understand how long it's going to take for a medical condition to evolve, or how much that picture may look. It's every situation is unique, and it's important to be able to go to have that ongoing dialogue as necessary between the parties. And again, the physician cannot include diagnosis, any specific prognosis in medical terms, any kind of treatment details such as medications, for example, or any sensitive or unrelated medical information. So it's the right amount of information at the right time that's important here.
Wonderful. Thank you, Dr. Hartfield. For this next question, I want to start off with you, Dr. Hartfield. How can organizations build a culture of trust so that employees feel comfortable reporting health concerns without a fear of discrimination or judgment?
Yeah. I think sort of wearing my regulator hat and then also my leadership hat, I can kind of think about this in two ways. I think, employees really need to understand that what organizational policies exist. So if a health issue arises, they know how they will be treated, and this should be fairly and respectfully. It's also important that the people leaders in organizations have a clear understanding of the policies so that the organization's consistently behaving and responding to the needs of their employees to avoid any challenges that might arise. Again, it's really important for the employers to focus on functional information only and not the medical details. When employers are requesting information from physicians, they should only ask for what's actually needed and to avoid some of the challenges that might occur if there's overreach. And the information really needs to be used to understand what accommodations might be required to support the success of the employee. I think it's important as well for the employees to understand how their medical information may be utilized, who's going to know on the team, and how it's going to be stored so that they can feel really confident and comfortable in providing the information that's required. As well, employees, should be supported for medical issues that arise so that they're able to return to work successfully. And that'll enable safety in the workplace so people feel comfortable and confident reporting a health concern before it's too late, or to a point where it may be impacting performance. And if there's that trust within the organization, these things are really vital to being able to enable employees to be successful in returning, and it builds confidence within systems. Another thing that we would also suggest is when necessary is to ensure that you use occupational health expertise. This solid advice can really help employers make good decisions about accommodations and functional capacity and ensure that return to work planning is safe, realistic, and really tailored to individuals. And that further reinforces that trust in the system.
That's great. Thank you, Dr. Hartfield. Leanne, I'd love to hear your thoughts and suggestions on this one.
Yeah, so Dr. Hartfield covered a lot off there. I'm going to focus my answer on the employer's attitude. So I touched on this a bit already, but I think it's important for employers to know the difference between what they can legally ask for and what it makes practical sense to ask for. Always requiring the maximum amount of medical information possible is not super conducive to building a culture of trust in the workplace. I typically recommend my employers to trust their employees and give their employees the benefit of the doubt unless or until an employee violates that trust. So I'm not saying here to never ask for medical information and just take your employee's word for everything, but I am saying that in deciding when and what level of medical information to ask for, start from a place of trust. Another thing that I'll quickly highlight is that every single request for an accommodation provides an employer with an opportunity to build a culture of trust, both in terms of the employer's relationship with that one employee, and then also in terms of the employer's relationship with all other employees who may be aware to one degree or another that one of their colleagues is dealing with health issues and receiving accommodations.
That's really helpful, Leanne. Thank you. Turning to you, Sanjana, what would you add to this?
Yeah, so both Dr. Hartfield and Leanne raised some excellent points. Just to build off of what Leanne said about employers, trust comes from how employers handle medical information. If employees know their privacy is respected, that the process is supportive, not punitive, and managers are trained to ask the right questions, they are much more likely to come forward early. Consistent, respectful treatment builds a culture where people feel safe disclosing health issues without fear of stigma or discrimination. Employers should clearly communicate that any medical information received will be treated respectfully and kept private. A well-written confidentiality policy, one that outlines what information may be requested, why it is needed, or who will have access to it, goes a long way in building that trust. When an employee requests accommodation, an employer can point them to that policy and walk them through the process so they understand exactly what will happen with their private information. A strong policy protects both employees and employers. When an employer can show that they have a clear process for handling accommodation requests and that they follow that process in a particular case, it becomes much more difficult for a discrimination complaint to succeed. In many cases, a complaint may be dismissed at the director's screening stage on that basis alone. And if it proceeds, I will often have to speak candidly with the complainant about the low likelihood of success when a reasonable policy existed and it was followed by the employer. The opposite is also true. If there is no policy in place, or worse, the employer fails to follow their own policy, then the organization is exposed to liability. In those circumstances, a complainant may be able to show that their accommodation request was mishandled, which can support a finding of discrimination. Clear policies send a message. The organization takes accommodation seriously and is committed to handling medical information appropriately. Communicating that commitment helps employees feel safer coming forward with health concerns. Supervisors and HR personnel must also know what they can and cannot ask. Proper training creates consistency across the organization and strengthens that foundation of trust. So seeking legal advice, such as through Leanne or her firm, can help employers develop strong policies and provide effective training. These resources set employers up for success and give employees the confidence that their request for accommodation will be handled properly.
Thanks, Sanjana. Great points. The next thing I would like to speak to is about privacy and information collection. So, from each of your experiences, what are some of the best practices when dealing with sensitive medical information? And Leanne, given your expertise in this area, I would love to hear from you first.
Sure. So, as I mentioned in my answer to the first question, some employers use third parties for this. And from my perspective, that tends to be the best approach when it comes to protecting sensitive medical information. Having said that, I understand that that approach isn't really feasible for all organizations, particularly smaller ones. So, what other things can an employer do to safeguard sensitive medical information? I think one, it's important for employers to identify a single person in the organization to be responsible for collecting and reviewing the information. That person will oftentimes be in HR. And then second, employers should ensure that that individual is only requesting, collecting, and then disclosing any sensitive medical information to the extent that is reasonably necessary. So, for example, that single person should be really careful about what medical information they ask for. They should ask for the minimum that they need at that point. And as mentioned earlier, they can always go back afterwards and ask for more if they end up needing it down the road. And then, of course, that single person should only be sharing the information with others to the extent that others have an actual need to know that information. So an employee's manager may need to know certain accommodations that the employee requires, but they probably don't need to know much else, like the reasons why, for example. And then the last thing I'll quickly flag here is that clear policies and procedures and training are important. Sanjana just emphasized this as well. The individual within your organization who is responsible for collecting and reviewing the information absolutely needs to have a good understanding of what it is they can ask for and how they can use that information. But don't just stop your training with that individual, because it's important that as others in the organization understand the limits of information sharing here too. So an employee's manager, for example, needs to know why they're only getting a snippet of the information and they're not being provided with absolutely everything.
Thanks, Leanne. Those are really important considerations. Appreciate you sharing them. Dr. Hartfield, what are your thoughts on this?
For for physicians who are involved, it's important for them to understand what their role is. And really, it's that disclosing only the minimum necessary information under these circumstances and with consent of their patient. So, as we've discussed, this means functional capacity and not diagnosis or treatment details. Any release of information, physicians are obligated to follow the privacy legislation and our standards of practice, and again, must be based on informed consent from the patient. If an employer has occupational health services within their organization with proper safeguards, that might be the other place that we sometimes end up connecting with as healthcare providers. And again, those parts of the organization will collect that limited health information, again, only with clear consent. And again, the information that employers receive is functional information only to help to coordinate accommodations. And so with that communication, that back and forth between the organization engaging with the employee and the relevant healthcare providers is, fine-tuning that information over time as the medical issue unfolds so that the employer understands what they need to do to modify duties to accommodate. And again, that nobody else should be seeing the medical details within the organization. It's that limiting focus. So from a regulatory standpoint, really the key sort of principles are protection of that information by limiting disclosure and focusing on function rather than medical specifics.
Thank you, Dr. Hartfield. Sanjana, I would be curious to hear from you on the Commission's perspective.
Thanks, Sarah. So from my perspective as Director's Counsel, there are two issues that come up repeatedly in complaints involving requests for medical information. First, employers are asking for too much medical information. And second, too many people inside the organization are accessing or have access to that information. These errors are preventable, and both Leanne and Dr. Hartfield has touched on ways to do that. One being limiting the focus of who has access to that information, either through assigning one designated individual in the organization or screening the information to see who needs access to this. So human rights law requires information to be minimally intrusive, purpose-specific, and shared strictly on a need-to-know basis, as Leanne pointed out. When employers respect these limits, they dramatically reduce the risk of a complaint. So what are some best practices that can be adopted here? Well, they can include storing medical information separately from an employee's personnel file and in a secure place. This also ensures it's accessible only to people who are on a need-to-know basis, and the information is retained only for as long as reasonably necessary. Also using standardized forms when seeking medical information to ensure consistency and reduce unnecessary disclosure. So the Commission's guide on obtaining and responding to medical information in the workplace has both a sample medical absence form at page 18 and a sample medical ability to work form at pages 19 and 20. Another best practice to implement is documenting all steps in the accommodation process, including what information was requested and why, how the employer relied on the information, and what alternatives were considered in response to the accommodation request, if any. The Commission has an accommodation toolkit that is a helpful resource in navigating the accommodation process, and we will share the link to the toolkit in the chat box. I also encourage employees to keep a record of the steps they took during the accommodation process, including their communications with the employer. By the time a complaint reaches me, it is not uncommon for several years to have passed since the events occurred. Memories fade, details get mixed up, and it becomes much harder to reconstruct what actually happened. So clear documentation helps preserve those key details and provides an accurate timeline of the process. This record can be critical in assessing whether the accommodation request was handled appropriately and can significantly strengthen the employee's ability to explain their experience. So I now want to briefly discuss some cases that illustrate real-life examples of handling medical information in the workplace. The first case that I want to discuss is called Schmidt versus 420 Premium Market Limited. It's a 2024 decision from the Alberta Human Rights Tribunal. And don't worry, the names of the cases along with the hyperlinks will be included in the chat box. So this case involved an employee, Mr. Schmidt, who had taken medical leave for surgery relating to a pre-existing disability. Mr. Schmidt was a paraplegic following a traumatic accident, and the surgery was related to that. When he expressed a desire to return to work following his surgery, Mr. Schmidt's employer, 420, requested updated medical information confirming that he could return to work safely and identifying any accommodation needs he may require. Mr. Schmidt did not provide sufficient medical information to support that he was fit to return to work, nor did he supply documentation to show what accommodations he might require. For example, he stated that his surgeon gave him verbal confirmation on his ability to return to work, but refused to provide an actual letter from his doctor. When asked to provide a letter from his physician clearing him to return to work and identifying any requested accommodations based on medical limitations and restrictions, Mr. Schmidt only provided his post-surgery discharge papers and took the position that he had exhausted his obligation to provide any further medical information regarding accommodation. Because of that lack of information and lack of explanation for why what was provided was adequate, the employer's duty to accommodate was not engaged, and the complaint was dismissed by the director at the screening stage. The dismissal was later upheld by the Alberta Human Rights Tribunal. So this case highlights two key points that we've been discussing in our previous answers. Employers are entitled to ask for follow-up medical information, and employees need to cooperate in the accommodation process. Another case worth highlighting is Greedanos versus Interpipeline Limited, a 2023 decision of the Alberta Human Rights Tribunal. I reference this case because it illustrates circumstances where an employer does not have a duty to inquire or a duty to accommodate. So Mr. Greedanos was a job applicant who applied to work with Interpipeline Limited in a safety-sensitive position. He received a conditional offer of employment from Interpipeline that was subject to him successfully passing a pre-employment drug test. Unfortunately, the drug test came back positive for cannabis, specifically THC, and Interpipeline withdrew the offer of employment. It was only at this stage, after Interpipeline revoked the job offer, that Mr. Greedanos disclosed that he had a physical disability. Specifically, he suffered from Hashimoto's disease, and he used cannabis and CBD to manage the symptoms of his disability. The tribunal found that while Mr. Greedanos had a protected disability under the Alberta Human Rights Act, specifically his Hashimoto's disease, and had suffered an adverse impact due to losing his job offer, Interpipeline did not discriminate against him. At the time of revoking the job offer, Interpipeline neither knew nor could they reasonably have known that Mr. Greedanos used medical cannabis for a disability. He did not disclose this during the hiring process or in the drug test questionnaire or after his drug test. He only disclosed it once the employment offer was revoked. Because there was no knowledge or reason to suspect a disability at the time the job offer was revoked, neither a duty to inquire nor a duty to accommodate was triggered, and the tribunal dismissed the complaint. So some important takeaways from the Greedanos decision are that the duty to inquire is limited, An employer's duty to investigate or ask further about a possible disability arises only when they know or reasonably ought to know about a disability or potential accommodation need. Absent any disclosure or red flags, that duty may not exist. And disclosure matters and timing is critical. Employers are not required to accommodate disabilities or medical needs of which they are not aware. If the applicant does not disclose their disability, or in this case, medical cannabis use tied to a disability, before or at the time of a conditional offer and associated drug testing requirement, the employer may withdraw the offer without contravening human rights protections.
Thank you, Sanjana. Great examples. Really appreciate you sharing those. I'm going to go on and move to talk more specifically about accommodations. So this next question is, what are the rights and responsibilities of an employee in providing medical information in the accommodation process? And I know you've spoke a little bit to this, Sanjana, but I was hoping you could elaborate a little more. And so I'd like to start off with you.
Absolutely. So employees have the right to privacy and to be accommodated without having to disclose unnecessary medical details. That is something that all three of our answers have covered, and it's just a well-established fact. The employee's responsibility is to let the employer know they need accommodation and to provide enough medical information that is focused on functional restrictions, not a specific diagnosis, to allow the employer to understand the limitations and explore solutions. Ultimately, both sides have to participate in good faith so the accommodation process can work effectively. And a case I want to discuss here, because I think cases help provide real life examples, is Woods versus North American Construction Group, Inc., which is a 2022 decision from the Alberta Human Rights Tribunal. So Mr. Woods was an employee of North American Construction, and he underwent surgery in 2011, which required him to be away from work for over 2 months. Mr. Woods filed a human rights complaint against North American Construction, claiming that they discriminated against him by failing to accommodate his workplace restrictions upon his return to work and eventually terminating his employment. Now, in order to establish a successful case for discrimination, a complainant has to show, 1, that they have a protected ground, 2, that they experienced an adverse impact, so something negative happened to them, and 3, that there is a connection between the protected ground and the adverse impact. Mr. Woods and North American Construction do not dispute that he experienced an adverse impact, that something negative happened to him. However, what they did disagree on is whether Mr. Woods even had a protected ground. Specifically, Northern American Construction took the position that Mr. Woods had no disability. So following his recovery from surgery, Mr. Woods was cleared by his doctor to return to his usual employment. And his usual employment prior to surgery was working day shifts. However, unknown to Mr. Woods, during his absence, North American Construction changed its shift scheduling policy. This meant that instead of working his prior day shift schedule, Mr. Woods was now required to work a rotating schedule alternating between day and night shifts. Now, he suffers from a gastrointestinal disorder, and the consequent acid reflux symptoms for Mr. Woods were especially worse at night. As a result, he was able to obtain a medical note from his doctor supporting his request to be assigned only day shifts because working nights would aggravate his reflux and his post-surgery recovery. North American Construction refused the accommodation request, treating it as a personal preference rather than a medical necessity. At the tribunal, they called their own expert who concluded that working nights would be acceptable for someone in Mr. Woods' position. Instead of accommodating Mr. Woods' request, North American Construction allowed Mr. Woods to go on long-term disability, and some months later, as part of a broader layoff, he was terminated. North American Construction admitted that Mr. Wood's accommodation request and the refusal to work rotating shifts factored in the decision to select him for a layoff. The tribunal accepted the evidence from Mr. Wood's physician and concluded that his acid reflux condition and post-surgery recovery qualified as a physical disability under the Alberta Human Rights Act. On accommodation, the tribunal found no evidence that North American Construction ever seriously explored accommodating Mr. Wood's medical restriction. The fact that he wanted day shifts only before deciding to lay him off. They did not show undue hardship. The refusal to accommodate the shift restriction, followed by the layoff and termination, amounted to discrimination on the basis of physical disability. And I think there are several key takeaways from the Woods decision. First, medical conditions that are not classically recognized, for example, acid reflux plus post-surgery recovery, or another one that we're starting to see, multiple chemical sensitivities, can still qualify as a protected disability under human rights law if they impact a person's ability to work under modified conditions. Employers must treat accommodation requests based on medical information seriously. They cannot just dismiss them as mere preferences. Even where a layoff appears to be part of a broader business decision, selection of an employee for layoff can still be discriminatory if medical disability and accommodation needs were a factor in selecting that particular employee. Failing to engage meaningfully with accommodation, for example, through shift scheduling or modified duties, or refusing to do so out of convenience and efficiency considerations can lead to a finding of discrimination. And finally, the duty to accommodate is not hypothetical. Employers need to consider actual medical evidence and balance accommodation requests against true operational hardship, not convenience.
Thank you, Sanjana. Great points. Turning to you, Leanne, what else would you add?
Yeah, I think the first thing I want to highlight is that while employees absolutely have a right to privacy, that right isn't without limits. And so, in particular, when an employee is seeking an accommodation for a mental or physical disability, the law dictates that they will have to give up some of their right to privacy. And that's something that Sanjana mentioned earlier. It relates to the fact that the employee is under a duty to cooperate. So putting that another way, accommodation is a two-way street. Generally, in order to obtain accommodation, the employee has to provide the employer with some medical information. And that right there will have a little bit of an effect on the employee's privacy. So the Commission's guide also sets out this statement really clearly on page 6. An employer cannot meet their obligations to provide reasonable accommodation if the employee does not release reasonably necessary medical information. So there are a couple of cases that I'll quickly refer everyone to. The first is United Nurses of Alberta, Local 33, and Capital Health Authority. That's a 2008 Court of Queen's Bench decision, as it then was. And the second case is Wearmouth and West Fraser. That's a 2021 Alberta Human Rights Tribunal decision. Now, in both of those cases, the employees provided their employers with some medical information. However, when the employers followed up with the employees for further information, mostly in order to help the employers understand the specific accommodations that were being recommended by the physicians, the employees declined to provide that additional information to the employers. And the decision makers in both of those cases, so the court and the tribunal, determined that the employees failed there. They didn't provide their employers with sufficient medical information, and thus the employers could not accommodate the employees in those circumstances. So again, an employer is entitled to know specific things. There's that helpful list on page 6 of the guide. And if an employee fails to provide any of that information when it's requested, then the employee has failed to satisfy their part of the duty to accommodate.
Thanks, Leanne. Dr. Hartfield, from your perspective, what level of medical detail can an employer reasonably expect from a physician to support workplace accommodation? And what can employers and employees do to better support medical professionals in providing needed medical information?
Sure. So again, employers should receive functional information only from physicians. So again, no diagnosis or treatment details or clinical history. So it's that minimum amount of information that should be provided so that there's an understanding of what a person's able to do in their workplace. So very specifically, this is related to their functional capacity. So what they're able to do and things that they should avoid. Understanding how their functional abilities would relate to the job's bona fide requirements, if that's known to the physician. They can also share expected changes over time if these may be predicted, such as when their abilities may improve or when a reassessment is needed by the healthcare team to determine maybe in a stepwise fashion a back to work plan or an accommodation plan. And some general recommendations for accommodation may be also provided by physicians, recognizing that these are limited if the physician doesn't understand the duties of the employee. So, and that really ties it nicely to the next question is what's better needed to support physicians who are doing this work and providing information to employers is really having clear information from the employer about the job's essential duties and physical or cognitive demands. So both of these are important so that the physician can tailor their functional assessments. Standardized forms that really focus on function rather than diagnosis are important. So the forms in the guide are really nice examples of that because it makes it easier for both parties to understand what is needed to be helpful to create an accommodation plan. Consistent expectations from employers help to avoid requests for unnecessary or inappropriate medical detail so that there doesn't end up being a debate between the provider, the employee, and the employer about I can't give you that because it's inappropriate related to legislation. So it's important that the employers understand what they're able to ask for as well. Physicians really can be the best partners possible in this process to support accommodation decisions when the information requested is functional, specific, and aligned to the actual job requirements. So those things are really important.
Thank you, Dr. Hartfield. That's extremely helpful to know. Let's talk about employers now. What are the responsibilities of an employer when they require additional medical information? Leanne, could I ask you to share your thoughts on this first?
Sure. So an employer may find itself in a situation where it feels like the medical information it has in front of it is insufficient at that stage. And like we've talked about, the level or amount of medical information that an employer needs will depend on the facts and circumstances. So what it means to be insufficient is going to change on a case-by-case basis. But in any event, if an employer ends up in that situation, then the first step is going to be for the employer to inform the employee of this and to ask the employee for further medical information. So an employer can ask the employee to go back to their physician to get that further medical information, or the employer can ask the employee for the employee's consent for the employer to reach out to the employee's physician directly. Important thing to flag here is that an employer absolutely should not reach out to an employee's physician without the employee's consent. So I get asked quite often by employers if they still don't get the requisite information from their employee, can they require their employee to undergo an independent medical examination or IME? And an employer's ability to do that is really quite limited. It can't simply demand that. That's considered to be a big violation of an employee's privacy. But that being said, an employer could ask an employee to voluntarily agree to one, and sometimes the employee will. And additionally, some collective agreements may set out such a right. But otherwise, an employer generally needs to have a really good reason to require an employee to undergo an IME. So page 11 of the Commission's guide provides a good summary of this. It says that the reasonableness of an employer's request for an IME will depend on the employer's basis for questioning the legitimacy, reliability, and or accuracy of the medical information that the employer has so far received. And some specific reasons for requesting an IME that the Commission provides include one, where the employee's medical provider provides inconsistent medical information or drastically changes their opinion on the employee's ability to return to work. Two, whether the timing of the information perfectly coincides with the end of the employee's ability to take paid time off work. And three, whether the employee's proposed return to work includes extremely onerous accommodations that don't really seem to be connected to the other medical information that's been provided. Of those three scenarios, the one that I see come up more often is the first one, where there are inconsistencies. And the last thing I'll do in response to this question is just quickly flag that for those who are interested, the guide mentions an Ontario case where the court held that an employee was indeed required to submit to an IME as part of the employee's duty to participate in the accommodation process. And that case is Batiglia and the Ottawa Catholic School Board, a 2017 decision.
Thanks, Leanne. That's really helpful. Sanjana, what would you add to what Leanne has shared?
Sure. So I agree with everything Leanne has said, and my answer is going to echo a lot of the key points that she raised. So I agree that an employer can request a second opinion or specialist only when necessary to assess accommodation with employee consent and respecting privacy. It's about clarifying limitations and finding solutions, not challenging the employee. Requests for second opinions should be limited to situations where the initial medical information is unclear, incomplete, or insufficient to assess accommodation. And I echo Leanne, in my experience, it's usually where it's inconsistent medical information that triggers the employer's duty to inquire and request further specification. With respect to IMEs, usually they can only be requested when the employee's medical information is unclear or insufficient to assess accommodation. It must be reasonable, focus on functional limitations rather than diagnosis, and respect the employee's privacy, with the employer generally covering the cost. The goal is to clarify accommodation needs, not to challenge or delay the employee's request for accommodation. I also agree with Leanne. Employers can speak to a physician only with consent and only to clarify functional limitations and accommodation needs, not to probe into relevant medical details. Employers may request information about functional impacts of medication on worker safety, but not detailed medical records or diagnosis. And any request must be reasonable, limited, and confidential. I also want to add that, once this information is compiled, employers are required to accommodate employees to the point of undue hardship. And undue hardship is not merely some discomfort or cost, it means significantly onerous conditions for the employer. Examples of what may constitute undue hardship include intolerable financial costs, serious business disruption, and what is undue hardship for a small business might not be for a larger one. So the context in which the undue hardship is being claimed is also extremely relevant. So a case that provides a helpful review of undue hardship is Prescott versus Alberta Health Services. And this is a case where Ms. Prescott was an employee with AHS. She was diagnosed with chronic inflammatory response syndrome, CIRS for short, which is a condition where a person has sensitivity to certain environmental factors like mold. And because of her condition, Ms. Prescott requested certain accommodations, like testing the building environment to check for mold or water damage, being allowed to work in buildings that were confirmed as safe, possible remote work, or a temporary or alternate role while AHS worked with her to find a suitable permanent option. AHS refused to undergo the building testing and also refused the other accommodation proposals. They maintained that Ms. Prescott was uncooperative and she was ultimately terminated from her employment. The tribunal in this case concluded that AHS had failed to accommodate Ms. Prescott's disability. On the question of whether AHS had demonstrated undue hardship, specifically that accommodating Ms. Prescott would impose an excessive and unreasonable burden on AHS, the tribunal found that AHS failed, and they made the following observations. AHS relied on a blanket or generalized refusal. For example, they rejected the requested testing because it was not standard practice, but didn't actually assess the accommodation request on its individual merits, nor did it provide an explanation for why an organization as large as AHS would face undue hardship in carrying out this building testing. AHS never engaged meaningfully with the accommodation proposed by the complainant. So she proposed several accommodation options: the building testing, remote work, alternative assignment, temporary role, and there was no evidence that AHS had even considered any of those proposals that she had put forth. There was no evidence that accommodating Ms. Prescott's proposals would have caused substantial operational disruption or intolerable cost or other hardship to AHS that would meet the threshold of undue hardship. Because AHS did not properly explore or engage with reasonable accommodation options and offered no concrete evidence that such accommodation would create undue hardship, the tribunal found that they had not satisfied their burden, and so they were in breach of their duty to accommodate under the Alberta Human Rights Act.
Thank you, Sanjana, and it's really helpful to get that additional context around undue hardship. Dr. Hartfield, turning to you now, is there anything you would add from your perspective?
Sure. I think a couple of things come to mind for me that I'd like to highlight. Back at the beginning, when we were speaking about completion of forms, one of the things that I had mentioned, it's important for the physicians who are involved to complete forms to the best of their ability and really to stay within the scope of their practice. When we're speaking about some of the reasons why an IME might be sought, can be related to the consistency of information and the kind of the quality of the response that the employer is getting. And I think those two things, might be related in some circumstances. So if you have you need to make sure that you're engaging with the right provider who's in the circle of care of the employee who can best provide the information. So sometimes that's not always the primary care provider. It might be the surgeon, for example, that had done an operation who could best explain what to expect for recovery and to help arrange accommodation. So I think that's one of the things that I would put forward. Because sometimes it does fall to the primary care providers, and they might not be the best person to give that level of information to help to support accommodation requests. I'll just also highlight that the role of the physician wouldn't be to arrange if it's a primary care provider, a second opinion or an independent medical examination in this circumstance. So the regulated members wouldn't be involved in part of that process. The other thing that might arise for us at times when we see complaints is what is our role as a regulator to determine when an IME is appropriate or not. And this is not the role of the medical regulator or the physicians involved in the care. This decision really lies between the employer and the employee. And that's under an entirely different framework. That said, we do have physicians who do independent medical examinations as part of their practice. And we do have a standard of practice that provides guidance for physicians who are doing this really important work. And this again ensures that the physicians who are doing the non-treating medical examinations ensure that there's informed consent by the employee. The examiner is objective and independent, and again, is only sharing with the employer information that's limited to functional capacity and ability to meet bona fide job requirements. No diagnosis or unnecessary medical detail.
Thank you, Dr. Hartfield. For our next question, I'm wondering what policies an organization should have in place to handle sensitive medical situations with care and compassion, while also ensuring their legal obligations are met. Leanne, what suggestions do you have for those listening in?
Sure. So from a policy perspective, you'll want to make sure that you're following the covering topics: privacy, accommodations in the workplace, and time away from work or leaves. And there are a number of benefits of addressing those topics in one or more policies. It should help the employer to know what to do, provide a roadmap when these situations arise. The policies should also help employees know what to expect. And then policies can also help to ensure that employers are meeting their legal obligations and doing so consistently from one case to another. But I also just want to be really clear that in many cases, what an employer actually does is far more important than what a policy says.
Thank you, Leanne. And that's such an important reminder. Sanjana, what would you add here?
I agree with Leanne. As we discussed earlier, it's important to have policies that set out the accommodation process. It's also important to have policies to address confidentiality and privacy of information. Organizations should have clear policies that respect privacy, protect sensitive medical information, and outline how employees can request accommodation. So these policies should ensure compassionate, individualized responses to mental health or terminal illnesses, provide manager training on duty to accommodate, and emphasize collaboration to find workable solutions. The goal is to balance operational needs with legal obligations and a culture of care and respect. And as Leanne pointed out, it is the practice actually implemented by the employer that is key here.
Thank you, Sanjana. Another question we often get here at the Commission is around performance issues. So from each of your perspectives, how should managers approach an employee to discuss performance issues that may be linked to an underlying medical condition, while also maintaining a focus on job functions? Sanjana, let's start with you on this question.
Sure. So in this situation, managers should focus on specific job performance issues, not the employee's medical condition. They should create a confidential, supportive environment, invite the employee to share relevant functional limitations voluntarily, and work collaboratively to explore accommodations to help the employee succeed. Confidentiality, clear documentation, and follow-up are essential throughout the process.
Great points, Sanjana. And what would you add to this, Leanne?
Yeah, when performance issues arise, it's important to remember that the employer and the employee are actually, in many ways, on the same side. The employer wants the job done well, and the employee typically wants to do their job well. So the starting point for the conversation is, what can we do to get the employee performing their best? Now, if the employer thinks that an underlying medical condition may be at play, then I have two important tips. The first one is, don't make up your mind that an underlying medical condition is causing the performance issues. It's good to be aware of it and to think about it, but don't have reached that conclusion before having a conversation with the employee. And in that regard, it's important to remember that a perceived mental or physical disability is just as much a protected characteristic under the Act as a confirmed mental or physical disability. And then the second tip that I have is, during the conversation about the performance concerns, an employer needs to make sure that they're leaving room for the employee to raise an underlying medical condition if the employee has one. So that might look like the employer saying something like, we've noticed that you've been arriving late, your productivity is a bit down. Are there any circumstances that are contributing to these things that we should be aware of? And this kind of relates to the employer's duty to inquire, which we talked about earlier today. If an employer knows or ought reasonably to know that an employee requires accommodation, then the employer must make that type of inquiry.
Thanks, Leanne. That's really helpful. Dr. Hartfield, what would you add to this from your perspective?
Yeah, I would agree with everything that's said. And it's really important to keep the conversation focused on job function and performance and not to make any medical assumptions. I think sometimes people leaders will have some discomfort in asking the question in that neutral, supportive way. It's good to practice, and it gets easier the more often you do it. If you know that you're involved in a performance conversation, and there are some things that make you wonder if there might be something else that's going on, and it's your obligation as the employer to ask, are there circumstances affecting your ability to perform your duties that we need to be aware of? And just again, that non-judgmental, open way of engaging your employees is really important to be able to help move forward to help people perform better. And if they do disclose something to you, then it's important to, again, focus on not diving into what's the diagnosis and what's happening with you, but really understanding, putting a pause on the performance management and understanding functional capacity and what duties are affected and what the next steps might be in that process.
Great additions. Thank you so much, Dr. Hartfield. And with that, we have reached the conclusion of our webinar. Great job to our panelists for their amazing insights. In follow-up to our discussion today, please find additional resources and contact information for our panelists, both on the screen and in the Zoom chat. And we invite you to reach out if you are interested in any of the resources that were mentioned or in learning more about the information shared over the course of today's discussion. With that, we have reached the end of our webinar, and you will now see a short survey pop up on your screen. So please take a few minutes to fill this out for us. This information, as I mentioned earlier, is invaluable for us as we evaluate today's session and plan for future webinars. And as you fill those out, I would like to extend my sincere gratitude and appreciation to our three panelists for sharing their time, their expertise, and their experience with us regarding human rights and medical information in the workplace. Thank you all. It has been such a fantastic discussion and has given us a lot to think about, and more importantly, to action. So we welcome you to follow the Commission on our various social media channels, including LinkedIn, Instagram, and Facebook, in order to keep receiving timely updates from us. And a final thanks to our incredible panelists and to everyone who took the time to attend today's session. We look forward to welcoming you to future learning opportunities. And with that, I wish you a wonderful rest of your day and see you next time. Thank you.